You can start.
Yeah, hi, this is Kumar Nikhil. I'm the host of this weekly webinar series of LawSikho. Today we have with us Mr. Nitish Banka. Nitish is an advocate in Supreme Court of India. He is a first generation lawyer. Nitish is an expert in builder disputes and litigation. Uh, he is going to talk about a very important topic, which is strategy for defending your client in dowry harassment cases, legal tactics, and best practices. Now, Nitish, before we come on the topic, I would like to understand, and this is for all our viewers and listeners, this may inspire them a lot, that what exactly prompted you? Your journey is completely different. What exactly prompted you, motivated you from being an IT consultant working in an IT firm to come into a different world altogether, which is a world of litigation? If you could share some insights on that, Nitish.
Yeah, thanks Kumar Nikhil for calling me today and interviewing me. I never thought that someday I will be called on such interviews, because when I started, I didn't had any idea where and what I have to build and why I'm here. Like you said, why I am here. I was also thinking why I was doing a very good IT job. I was very good
Correct.
reputed IT company. People dream of getting into such companies and be a part of such big organizations. So and obviously scale the corporate ladder and become one of the top notch CEO executives and all that positions. But then one thing was deep inside me was that I have to do something about that should be mine, not like I'm doing this for someone else. I want to do everything for myself at least, so that I have this thing, my own identity basically. So the idea was to make my own identity. It's not that I wanted to go into the matrimonial litigation or matrimonial expert, but the idea was to have an identity to be known for that. You need some niche, some area where you are specializing. So I started way back in 2014. I used to post articles, and I can see many of my own subscribers are here on the panel, and they are posting lot of questions because they have lot of questions. The beauty of these questions is that these questions, through answering all these questions, I am what I am today, because I could able to understand their problems and then solution, then understanding problem solution. So it's a repetitive cycle, and within a span of 9-10 years I have been able to do whatever what I have dreamt of basically.
No, it's a great story, and thanks for sharing the insights. I'm very much sure that the audience today would definitely get lots of motivation listening to your story, because normally the trend is that people go to corporate jobs. Generally, if you look at it, corporate law, or even if not law, then corporate jobs, people tend to prefer that. But you are someone who has shifted, who has made a switch, conscious switch from the corporate job to a litigation practice area, and you are really doing well and great in that. So thank you,
Yeah.
Nitish, for sharing.
Thank you.
So
Thank you.
yeah, yeah. So coming to the topic, which is I think very pertinent, very important, which is strategy for defending your client in dowry harassment cases, legal tactics and best practices. My first question to you, Nitish, is, and it's a question and also a request, that can you share some insights on the legal framework and dowry harassment laws, which our audience can really get, they can learn from it.
Right. So, see, the dowry harassment laws, or mainly the entire matrimonial litigation, is divided into three parts, four parts in some cases, but normally it is three-way war. Okay, one is the
Mhm.
maintenance related, which includes 125 CRPC and the Domestic Violence Act. One is the criminal side, which is the dowry case, 498A, 406. These are the common thing. Another one is the divorce. the divorce related things that husband or wife puts to get out of matrimonial litigation, to
Mhm.
end the marriage. That is the only. And the fourth one, which is quite very sensitive, and it's applicable in few cases, is the child custody and the child related matrimonial disputes. So
Correct.
these are the four pillars, or the four areas in which you're one of either three of the things you will be doing, two may be doing, or one may be doing. But these areas will be there for a in a matrimonial litigation.
Mhm.
So based on your problem may lie in four of the things which I mentioned.
Fair enough. So yeah, so thank you for that. My second question to you, Nitesh, is that if you could talk about the role of defense counsel, which is, I think, very important in this entire scenario in dowry cases. What is the role they play?
See, obviously, the husband side is implicated in all these cases. Husband and the family of the husband are implicated in the. Suppose we talk about the criminal side, that is the 498. If we first, as I discussed, there are four pillars. So one
Mhm.
is the criminal side. I'm discussing the 498 case. So I travel all across the country to at least save the parents, because parents are the one who are the soft target in all these matrimonial issues. Even the courts are now very sensitive. So honorable Supreme Court to high courts, I have
Mhm.
experienced, in my own experience, I have seen that for the parents, even if there are certain allegations, the honorable Supreme Court or the high court quash against the parents, in-laws, brothers, sisters, all these relatives. So that is the area which very few people explore, and entire family then goes through harassment. So first is
Mhm.
to reduce the harassment to for and exclude the family members. That is the first priority I have. Then we
Mhm.
have a pressure from the police side. When we face all this dowry harassment, we face pressure from the police side. For that, anticipatory bail we recommend. Generally, nowadays 498A has become lighter, but still lot of people face harassment from the police station. Police calls you to police station frequently, pressurizing you, maybe motivated by the other side and all that. So these are the two main things which we do in the initial phases. After this, quashing and the bail thing, this is the first one is to removing the relatives is quashing, and the bail thing is the anticipatory bail and the bail thing, which relieves most of the stress of. Now when it
Mhm.
comes to trial, we then have a chance to argue on discharge. That is the first opportunity any accused will get, that to argue on discharge. But normally trial court doesn't discharge the entire case. The case goes on to trial, and then the main role of a defense counsel is to cross examine the complainant and their
Okay.
witnesses which are coming in. So there are
Mhm.
techniques to cross examine. Obviously that comes with experience, and then
Mhm.
we have the final argument and all that. So this is the criminal side of things. And and I majorly discuss about the maintenance part. Maintenance is a fuel for the wife, I can tell you. Once the wife puts in the maintenance case, obviously she wants money from you. Now to reduce that maintenance should be your first goal, to so that that fuel is cut off. Once the fuel is cut off, then only your cases will then get settled, because matrimonial
Correct.
cases are more likely to be settled in mediation and all. But if suppose your wife gets a 1 lakh rupee maintenance, why will she settle the case, or higher maintenance, why will she goes on and settle the case? It is only
Mhm.
when the maintenance is reduced to a minimum or zero, that is the only way out. So in maintenance side we have this strategy, and in divorce side we have the strategy related to evidence and all, which has a different judgments are there for proving cruelty, desertion, and all these aspects. And the final child custody case, we have visitation for the husband, that so that they can have touch with the courts, easily grant visitation to the husband side. So in nutshell, I'm telling you all these four things. We have certain kind of strategies to help our clients and the victims, mainly the husbands.
Sure, sure. And again, thank you for that, because our audience and viewers are gaining those insights which normally they don't learn in like 3 year of LLB or five
Yeah,
years of
it
BLLB and
takes a
LLM
lot of
courses.
experience in and out of this to know what exactly you have to do.
It's right from the war field which you are sharing, and I'm sure that the audience would be like immensely benefited out of your insights. Now
They can
coming to our
comment if
third.
they are getting some knowledge. They can comment.
Yeah, yes, they can definitely keep on commenting, keep on asking questions. What we will do right now is we will take Nitish through a set of some questions, and he will share his insights and knowledge there. If you want to ask anything, you can definitely do that in between and after that as well. The purpose is to impart as much knowledge as we can to the community. Nitish, coming to the next question which we have is that what are some of the evidentiary challenges and effective strategies to counter those challenges in dowry harassment cases?
Okay, so in dowry harassment cases, the challenge is that it is the onus is on the wife to prove the dowry and all. It is not on you.
Mhm,
Your main challenge should be to cross examine on those things which he has been doing. So your defense is this, like, suppose tomorrow I'm going for a cross examination, I tell you that your defense should be this, that the relation between you and your wife was normal, nothing was there she went for honeymoon, she had a good relationship with your parents, and in one of the pictures even the wife was sitting on the lap of the mother-in-law. How can you from this picture you say that
mhm,
she's having kids, the kids are happy, every occasion is being, like a normal family, everything was normal. So these things
mhm,
should come on record. And
mhm,
second thing is the contradiction. Like in one of my cases, the wife stated something else to the police, and in the court she's stating something else. So these are the
mhm.
contradiction that has to come on record, so as to
Okay.
counter. So more likely it's not that you don't say that I have not taken dowry, because there is no proof of you're not taking dowry. But whether the
Mhm,
statement of the wife is credible enough, whether the circumstances are credible enough, whether one on the one hand she's celebrating everything, she's sitting on the mother-in-law lap, she's having good family time every
Rapport.
occasion, on the in the years of marriage everything was, and one night someone poked her that you do all these cases, she went ahead and filed all this. So these things should come on record, because then
Mhm.
only the true picture and the true, this thing will come.
Sure. Thank you. And this is really very insightful to all of us. Dipanshu is saying, please check my questions. We will definitely do it, Dipanshu. Let us go through some questions uh, which we are going to ask, and then Nitesh would definitely be happy to answer all your queries. Nitish, if you could just please share with your audience some tips on mastering cross-examination techniques, which is very critical at all stages, if you look at it. So if you could just share some insights on that.
See, the art of cross examination is this, that you have to, restrict yourself in not asking questions which can damage your case. Suppose one of my client came in and he said कि आप इससे ये क्यों नहीं पूछते कि डाउरी कब ली मैंने, कोई इसने डेट तो मेंशन की नहीं गई है, इसने
Mhm,
she has not mentioned any date in the FIR. मैंने कहा are you nuts? If I ask this question, then obviously her case will become stronger. I can't ask this ki when you have taken dowry, when you have taken the Sridhan, when you have entrusted the Sridhan, when it is not there, it is not there. So
mhm,
there is always a tendency that you ask things which are not there. So never ask things which are not there. Let it be. You have to, be there. Let it be. You will use this as a defense. In the final argument, you will say that nothing, no date has been mentioned when the dowry was taken. No date was mentioned when the jewelry was entrusted, to whom it was entrusted. You never ask all these questions कि किसको ज्वेलरी दी थी आपने, किसको. So these are the question where you have the witness can explain. So all the explanatory questions should be avoided at very
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 important. Yes.
very important thing. This is very important, and lot of lawyers and even many clients do this mistake that whatever not in record they come in. What is the purpose of that other than strengthening the opposite party? वो तो आप अपना केस खुद ही उसके हाथ में दे रहे हो
खुद
एक
ही वीक
तरीके से.
कर रहे हैं, अपने पैर पे कुल्हाड़ी मारना हो गया
So
एक तरह
many times I have seen this thing happening. Then lawyers do what they do. Another thing is they only ask suggestions. Okay, suggestions is important. You give it in the end. Last week I was attending a cross examination of my client. The lawyer on the other side was only giving suggestion. मैंने कहा ठीक है, बढ़िया है, दे दो, कोई दिक्कत नहीं है. इसमें क्या है? इसमें कुछ नहीं निकल के आएगा. And the third thing is, the third fundamental rule is that you have to compare the statement given to the police and compare to the statement which is on the FIR and all. Once you compare that, you have to bring on record the statement which are contradictory. You have to ask that to the police, you have not said this. To the police, you have not said this. This statement, you have to highlight all these statements which she has mentioned in the examination in chief. You tell her that to the police, you have not said this. To the police, you are, it's when it is not there in 161. Okay, that is one thing. Then, like in the last question I mentioned, then bring all the surrounding circumstances on record which are in your favor, like the celebrations, the photographs, and everything that should come on record so that the judge sees the thing that yes, your at least half of your evidences will, obviously the common set of evidence will come on record. The photographs of you and her just confront with all the photographs and the maybe the messages and everything, that all will come on record. You don't have to then lead your evidence. Your half of the job will be over in the first cross examination only. Then you don't have to lead your evidence and get yourself examined in the cross examination, because that fact has been admitted. Once that fact is admitted, she will loses her right in the cross examination. She will not be able to cross examine you on that aspect. Bring all recordings, everything. Confront her with all the recordings, confront with all the WhatsApp messages or maybe everything, and rest whatever is left can be lead. You can lead in the your defense evidence.
Sure. Thank you so much.
So that's the best strategy.
It was really very insightful. Now, my next question to you is, how do we craft a robust defense strategy in these kind of cases, or any matrimonial cases?
See, it depends on the case to case basis. There's no straight jacket, this thing formula for any uh, defense is there. And the as I mentioned in the first instance, that for maintenance cases you have to keep it low. For that you need to find out where your wife is working or what sort of external income she is having. If she is having a child, and suppose if the wife is having child, she is not working, that is the most difficult, and they will never, the case will never get solved until you pay a higher amount. Because in this case either the court will fix a higher maintenance, or you have to be mentally ready to shell out money in that cases. If there is a child and the woman which is not working, once there are cases in which women are working but they have concealed to the court that they are not working. So here your job begins, that to find out where she is working, hire a detective, anybody, get that information. The main key is information. If you have the information, you can win these cases really fast, end these cases really fast. In one of my cases which happened last week, I submitted to the high court, I'm ready to pay 15,000 a month. Okay, but subject to the DV case which is running there, I want to fight it on merits. What happened in the DV case? Even after my voluntary submission to the High Court, client was saying, "How can you say you pay 15,000 and all that?" I said the judge was there. He will not grant you bail if you don't pay 15,000 a month. It is up to you. You want to do or you want do. Of course, in the end, he consented. Let's pay 15,000. I'm ready. I'm comfortable with 15,000 a month. But then what I did for that client, you will be shocked. What I did, I took DV case was running. I strategically did that subject to the outcome of the DV case. I'll pay 15,000 a month, and I knew the next month DV case hearing will happen, and the judge will pronounce the interim maintenance decision. There, I
Mhm.
what I did there was I put an application that the wife is working. She has concealed to the court that she is working. I filed a 91 application. Judge straight away asked the wife, "Where are you working? What is your salary? And you give me all the salary slip." She had to get all that salary slip. I said that this is a clear concealment, and on this ground, and she had a child. Problem was she had a child, and she showed that she's not working. But then the judge reduced the maintenance of the child also, because she is working. Let her pay the maintenance, and you pay only 7,000. So for
Mhm.
15,000 maintenance, which I voluntarily agreed, it was reduced to 7,000. So that's the victory you can look when you fight all these cases.
Sure, sure. Very, very helpful to the
Right.
listeners and viewers here. Now, coming to the next question, Nitesh, can you share some insights on exploring alternative dispute resolution ADR, which we very famously call it, in dowry cases?
Okay, so the beautiful part of matrimonial cases is that most of them get settled within a span of 3 years or so, 70 to 80%. But
Mhm.
where there is a wife and the child, either you have to shell out a heavy amount, then only it will get settled, or you pay up high maintenance. So that these are the cases which are very complex in nature, and you have to fight it all through. This will take years. Some of the cases may took 18 years also. One of my client is facing since stone ages. So mediation, time to time mediation, referring the matter to mediation will help to resolve these cases. And
Mhm.
I recommend my clients, I encourage my clients, see, even if court grants you maintenance, you have to shell up money. Instead of shelling up 10,000, 20,000 a month, you go for a full time settlement. And don't think that you have to pay up. It is for your own mental peace to get all out of, and you can continue, because the main thing is your time. The time you are spending on this litigation will never come back. Although the ADR and the mediation are not helpful for lawyers like us, but then I am a little, see, I am a generous enough that I tell my client to go and settle if you want to.
Mhm.
So
Sure.
mediation referral is quite common in matrimonial.
It's common and prevalent in India.
Even
Yes.
at honorable Supreme Court level, they refer it to mediation once it reaches there, or
Mhm.
at the
Mhm.
High Court level also. So it's very, very common.
Okay. Fair. And if you could just share your learnings from precedents, because precedents play a very important role in any litigation practice, be it any area. So, what role precedents and case studies have really played in your area of expertise?
Right. So as I said, for the maintenance law, for the criminal side, 498A law, and for the divorce, as well as for the child custody, there are four areas. In all those areas, there are landmark judgments of Honorable Supreme Court. For maintenance cases, you can use the guideline like Rajneesh versus Neha. That is the latest judgment. Everything, it's a Bible for the maintenance cases. If you want to understand how maintenance cases work, go through that judgment. Ranish versus Neha will help you. Then in the 498 cases for quashing and all, there's a recent judgment of Honorable Supreme Court, which is Kakasan Kausar. You can go through that judgment for relatives quashing, and it's very good judgment. Then there is a
Mhm.
judgment of Subarao also in 498 quashing and all that. Then,
Mhm.
if we go to the next stage, that is divorce, the mental cruelty, it's our Samar Ghosh versus Jaya Ghosh. That is the guidelines for divorce cases, how you get. And then in child custody cases, we have Yashita Sahu. That is a very good Supreme Court judgment, which you can go through, and you can get an idea how child custody cases are decided. In DV also, there is a recent change in law. So there is
Mhm.
a Pratibha Tyagi ki judgment hai. There is a judgment on
Mhm.
Pratibha Tyagi. You can go through Kamla Devi.
Mhm.
All these judgment are recent judgment 22 23. So these are the judgments which has been changed the entire matrimonial sphere in the last 3 years only. So it's a very, very good judgments which has
And it
come.
impacts your work tremendously in terms of quoting them and getting
Clears the law and everything behind the DB. Earlier, people used to tell that there is no limitation in 498, and then I said that go and read these judgments. You will find that there is no limitation in matrimonial law. Then
Mhm.
in DB also they used to tell that 1 year is the time. Then I
Mhm.
had to update them that read this Pratibha Tyagi judgment. This is what the law is changing a lot, and lot of clarity is coming in with these recent judgments which I have told you.
Yeah, and if I'm not wrong, Nitish, precedents really play a very important role not only in matrimonial cases but in all
Yeah,
aspects of criminal and civil litigation. They
right.
really carry lots of weight. Yeah, yeah,
Exactly.
yeah.
And then you have to design your strategies as per these judgments only.
Correct.
So, last week my one of my client came and he said that I have to pay maintenance from the date of this application, sorry, date of order. Okay, there's a difference. Interim maintenance is either from the date of order or date of application. I said you read Rajneesh versus Neha, which I have told you. There it is
Mhm.
clear. He brought some old judgment and said that in this judgment, because see, your judgment is also mentioned in this judgment, so it has been overruled. Don't go.
Mhm.
Just see, when you Google it, you will find everything. But when you experience it, your knowledge become focused. So you have to focus on few things, not all the things which are there. So he
Correct.
showed me the old judgment, and I said, "This is I've been overruled. See this judgment." So then he
This is very
agreed, and
important. Being
otherwise,
updated about.
what was
Yeah.
happening was he was not ready. I said I'll give you a stay order. I can get you a stay order provided you deposit 50% of the amount from the date of application.
Mhm.
And what happened? I was newly engaged counsel in that case. I went to the judge. I argued on that same which was client. अब client है तो मैंने कहा चलो थोड़ा सा तो oblige करना पड़ता है. Judge said कि वकील साहब आप ऐसी बातें कर रहे हो. You are a matrimonial expert और आप ऐसी बातें कर रहे हो. I said कि I know sir. He said that I'm sending your client to jail, and and I said to my client that see what I have said is what is doing. So now you want to go to jail or you want to pay 50%. He paid 50%. We got a stay order from the sessions judge. Now at least he is relieved. He's not going
Mhm.
to jail. Otherwise, if it was someone else who didn't had any knowledge, then he would have definitely gone to jail. So this is the difference between knowing the latest laws or not knowing the latest law.
Correct. And it really saves lots of time for the attorneys, for the lawyers, and the court as well, because you don't waste your time in reinventing the wheel. Coming to the next question, Nitesh, for you is, can you please throw some light on ethical consideration for defense attorneys and how that is important?
Right. So the issue is that in my 9 or 10 years of my career, I have never seen I've seen people complaining that my counsel has mixed up with the other counsel. He has a setting with the other counsel, and
Mhm.
that's why he's saying to settle this case and give the money to the wife side and settle this. See, the thing is, this client get it wrong. The issue is that you have to think long term. What we see is the long term. We see if your maintenance goes to maybe 40,000 or 50,000 a month. Suppose it will be 6 lakhs a year. In 5 years, it will be 30 lakhs. Right now, your
Mhm.
wife is demanding 20 lakhs. It's just 3 years of whatever you will get an order for. So go and
Mhm.
settle. Don't make a fool of yourself. That's
Mhm.
why we advise settlement, because we see that if this litigation goes 5 years, 6 years, how much
Mhm.
cost it will go to the client. Will it be cost effective or saving 20 lakhs and paying up 30 lakhs? How foolish is this? So that's why we advise our client to settle this thing. If she is asking 20 lakh, give it, because in if it extends to 5 years, you will lose your 5 years. You will lose 30 lakhs also. You will gain nothing.
Correct.
So it's a common sense, it's not that, and people feel
Mhm.
that this council has been mixed up with the other council. I don't know, without evidence or without any proof I can't comment on these things. But ethical thing is that yes, there are people who are unethical in the profession also, but I
Mhm.
have never encountered
You have not
myself.
experienced that.
Not, never. I most of the time I feel that it is a hoax. It is a thing which client create themselves because their lawyer is asking them for settlement. Just because we have seen a long term, we know the through experience, and that's why we tell the client to get it settled, and they think
Mhm.
that you have been unethical. But that's the only thing I have seen in
Mhm.
my past career.
Very good. Now, coming to the next question, Nitish, if you could just talk about the importance of effective communication and client management, the role of that, because I think effective communication and management, be it client or be it your time or whatever it is very important aspect of your work. So, in this specific area, how does this impact your productivity?
Right. So obviously, see, time management is non-negotiable for our lawyers, because we only get I tell you frankly, Kumar, you are in Supreme Court, and I know that till 3 o'clock or 4 o'clock you must be in court. Okay,
In court,
right, and
correct?
handling various petitions and all
Various
that and everything. You
running from court to court.
honestly tell me, after 4 p.m. you do have energy to put in work or something to do, or just you want to sleep? See, the thing is, our energy is not designed for 12 hours, 15 hours, 18 hours which we put in. My health also gets affected by all these things. So it is very important to manage your time. I know your 4 till 4 you will be in court, and after that also you have work. So you have to manage your work, and it should be like you work in your peak energy levels. If you're not in your peak energy levels, I feel that work will be like, it will create a pressure on you.
Mhm.
So there's no point creating a pressure on yourself. So manage your time like this. Suppose you're not putting in 12 hours, is fine, totally fine. But
Mhm.
what we have done in the legal profession, I have seen myself also a victim, that we have created this, that 15 hours days are normal for us. 18-hour days are
Correct.
normal for us. 11 p.m. we are sitting. But see,
The
your mental.
audience needs to know that.
See,
The
your
audience.
body is there, but your mind may be somewhere else. So it is very important to focus on your mental health and the physical health, because after you reach 30, like I'm 35 and all, and I'm experiencing this, that your body gives up.
Mhm.
My energy levels are not when I was 25, 24, but now I have to take extra care about my body and the mental health. If I'm not feeling
Mhm.
good, suppose today although I commute by car, I today took a cab. I said enough of driving. Even driving drains your energy and everything. So it is important to preserve your energy so that it can be utilized into most protective tasks, like reading, and maybe because reading will take a lot of your mental energy. And
Correct.
I think that reading should be scheduled in the morning hours, maybe 5 6 a.m. 1 hour is enough. I think one or
Mhm.
two hours, because in the morning hours your mind is fresh. After that you go to court, and then you come back and handle all the clerical things. So time management and team management is very critical for a successful practice, what I believe. Success
Fair
not
enough.
as a financial success, but from your mental aspect. Suppose your practice is going good financially, you are doing good. What is the purpose of that financial thing when your mental health is suffering? Your you are facing diabetes, BP, and all that. These you're taking a lot of
Doesn't make
medicine.
any correct.
Doesn't make any sense. So I think
Correct.
the legal professionals don't think much about these aspects. What
Mhm.
I have seen,
And what about
including
the
myself also. I'm also a victim of this, so I admit it.
what about this importance of effective communication skills and client management? Do you think it's very
Right,
critical skill to have?
right. So what I have done is that I have all the things which are online. Okay, I have an online group of people who can time to time ask questions. Like we have questions here. We have a group. We have a forum. It's a and I they can post me a query and I can resolve it in 8 hours, 12 hours. Then we have
Mhm.
online consultation management. We use software too for online consultation, so that unsolicited calls are avoided, because when you are in courts you can't receive calls, so it is better to have a calendar for
Mhm.
these calls and to answer the consultations and all that. And then you have this the whatever your clients are, obviously your team should be there to answer, give the status of
Mhm.
their cases, because the problem is this communication, lack of communication is bad communication. So I empower my juniors to take care of the client and have a good relationship with the clients, and tell resort is me if everything fails. I tell my juniors, unless the client is not going to jail, unless the client is going to jail, just then schedule a call with me, otherwise you handle all. So in
And
this
what
case,
about the yeah, please go ahead.
so this is the way to have a less load, because you can't take 25 30 calls a day. It is maddening for your brain, and it will not help you. So I
And
delegate everything.
what about communicating with the judges? Because if you look at the time which a lawyer advocate has, I would say like roughly 15 minutes, 20 minutes, because so how what is the strategy you should follow to present your case in front of the judge?
So first is to go through all the last orders in the file. That is the
Very
non-negotiable
important.
thing. The problem is most of the legal professionals are too busy. They don't go through the file and the last order. Half the problem will get solved if you go through the last orders and go through the files. Half of the problems will get sorted. Because when you go to court, you get a surprise. Oh, last date पे तो ये हो गया था, मेरे को पता ही नहीं है. So that creates a problem, because
Mhm.
then obviously depending upon the hearing and all, better to prepare your strategy beforehand, because that will
Mhm.
help you become more confident and face various challenges. So rehearsal is, I do a rehearsal thing, that what I think, 15-20 minutes, I think that what would be judge be asking me, and what I should be delivering. So I think this helps. For me it helps. And the preparation is the key. The preparation before the case is the key of communication.
Mhm.
If you're not prepared, then you will feel anxious. You will not feel confident at all. बिल्कुल भी you will be like हो क्या रहा है, कुछ नहीं पता चलेगा.
So the more prepared you are, the more confident you are, and that is what helps you in presenting your case more effectively.
Spend half an hour, 1 hour, that's it. You
Mhm.
don't have to spend hours. Half an hour, one
Mhm.
hour to read through the files, get everything. That is my only thing, because earlier also I was not very confident in court during the initial years, but
Mhm.
this habit of preparation before the case is listed uh,
Mhm.
gives me strength uh, about this preparation and all. And plus
Correct.
experience also helps. With experience you will, this time also reduces.
Correct. And that's the beauty of law profession, that with experience, your knowledge increases.
Everything gets
And
resolved. Yes, yes.
exactly, exactly. Now, this is my last question to you, Nitish. If you could just share some insights on managing public relations in high-profile cases.
Right. So Actually, I'm not the right person. I think you are the right person to answer this because see, I am in a journey. I have not reached there. That only the high profile cases comes to me. Uh, they come, but you know, I have good professionals who are there, who are, and I tell you, you need these clients only in your practice, because you
Mhm.
know they understand you. Only thing is that they understand your thinking, your way of thinking, and they're less likely to be emotional. They're more likely to be rational. And when I tell
Mhm.
them that a high profile client came, his wife was cheating,
Mhm.
and she was caught red-handed by her own son at their own
Okay.
bedroom. So this was the very high profile client I was dealing with.
Mhm.
I asked my client, see, that is fine. I'm really sorry, whatever happened with you. Okay. And uh, I, 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 I can't, even think what trauma you are going through.
Mhm.
And, and even I can't, uh, this, I can't even imagine what your son will be going through.
Correct.
But sir, there is a law, and law is this: even if your wife is cheating, you still have to pay, and your wife is not working. First of all, still you have to pay
Mhm.
up the alimony and the maintenance if you want to go for divorce. So and eventually this was the understanding I have given to this client. Although this was a very emotional moment for the client, and what I am telling is that you have to pay up. What is so now the client stature was so good that he was able to comprehend, even if in this critical situation he's able to comprehend, because it was a very big position. He was handling a leadership position basically. So he was able to comprehend whatever I was saying. So he
Mhm.
said that I want to get out of it fast. I don't care about the money. Okay, the
Mhm.
attitude is this. Now if the client is of not of that mentality, what he thinks that I want to save my 5 lakhs, I don't want to give my 5 lakhs. I'll pay you 5 lakhs, but I don't want to give them. I said the law
Mhm.
is there, you have to give 5 lakhs. Either you
Mhm.
settle it out, or you paying 5 lakhs, or whatever will happen in 3 years. So the problem is they can't see the vision. What will happen in 3 years, 4 years, 5 years? So this client of
Mhm.
mine took no time and said that whatever you. So we sat on the negotiable table, and I reduced 3 crores of alimony.
Oh,
I reduced
oh,
the 5 crores she
wow.
was asking, reduce
A
it to
huge number. Mhm.
one and a half, two, and that too in
Mhm.
10 years time. I said,
Mhm.
we'll fight it out. We have everything against you. You
Mhm.
want to
Mhm.
have the good view in and he hired one of the best lawyers
Mhm.
in Delhi. She hired one of the best lawyers in Delhi. So
Okay.
both were, it was a very high profile, high tension case, but it got
Mhm.
settled at a very, reasonable amount. So this is what the thinking about the high profile cases, and you should be focusing on that only, because
Mhm.
the problem is that you will have less headache, your strategies will be implemented faster, you will
Mhm.
not face much resistance, you will
Mhm.
not face trust issues, you will not face billing issues, everything will be sorted. So that's the my goal also, and I think that is the way you have to deal with such clients. It is
Sure.
easy to deal with high profile clients. I tell you, it is much easy to deal with high profile clients than the other clients.
Correct. I would agree with what you're saying.
Yeah, and you would definitely agree.
Yes,
You
yes.
come across more. I think we are on same page.
We are on the same page on this. Specifically. Thank you, Nitesh. I think
Kumar.
lots of insight from you, and I am very sure that the student community or the working community here would definitely get benefited a lot listening from you. Now, I saw a question on the comments group, which really uh, uh, I found it interesting, and this is relating to my question, which is about the effective communication skills required for an advocate to be a good advocate in the field of law. Is how English is important as a
Right.
language of communication, uh,
See,
and does it impact your career? Yeah.
see, I feel that at High Court and the Supreme Court level, your English communication must be good enough. Okay, not that you speak like Shashi Tharoor. I don't want to name, but
He is
still,
very complicated.
yeah, don't have to have that complicated this thing that I want to reach that level. I
Very
have
good
a
English, yes. Correct.
uh, uh, in that level और आप जो है हिंदी में भी बात कर सकते हो, कोई दिक्कत नहीं है। आप इंग्लिश में भी कर सकते हो, कोई दिक्कत नहीं। वो हमने परसेप्शन बनाया हुआ है कि हम
Mhm,
इंग्लिश में बोलेंगे तो हाई प्रोफाइल लगेंगे, हिंदी में बोलेंगे तो हम ऐसा नहीं है।
mhm, mhm,
Only thing is that abhi the thing is this, that the mindset is shifting. It's not that language is a issue. Most of
mhm,
my videos are in Hindi, if you can
mhm.
see. So, ऐसा नहीं है
Correct.
कि सिर्फ इंग्लिश ही is a you know it plays a role at courts level where you are practicing. Lower court it's Hindi, high court it will be English, unless you are in Rajasthan, Madhya Pradesh, that
Mhm,
they have Hindi as a official, and at the Honorable Supreme Court, obviously English. So,
mhm,
matlab, you need to improve that skill. Obviously, you need to improve and work on your language. That is there, but only language will help you. That is a wrong thinking.
mhm,
So
mhm,
you
mhm,
need to improve that. Yes, it is important. Yes, but only that is the sole criteria of success is wrong.
mhm. Fair enough. And that is really very insightful to the audience here, those who are listening to us, those who are looking at us. So we have answered all the questions which we had, Nitish. Uh, do we now open this discussion to the questions from the audience, or what is that we do?
So I
So
think
if
most of the questions are the legal questions. Should we
correct.
answer legal questions or?
So
Uh,
Arun Sharma is asking, please discuss DP Act 3 by 4. Can we use it against wife? She is claiming false DV case that her family paid dowry at the time of marriage.
See, the problem with the DP Act is it is not applicable to the victims. There's a section 6, I guess, 6 or 7, if you read the DP Act. Otherwise, no one will complain about dowry harassment. So, I don't think you can use this against the wife.
Mhm, mhm. Okay. And the Panshu is asking that what we do if any wife call maintenance after 12 years and both are separated last 12 years, then she can claim. Sir, this is
Right.
what the
If
Panshu.
she is your wife, is a legally wedded wife, she can claim at any time if she needs money.
Mhm, mhm. And then there are different questions. Wife in 498A falsely implicated brother and sister who reside in other states of India. What is that we can do?
So, like I mentioned in quashing, you can go for the quashing case in such cases.
Sure, fair enough. So I think I gained a lot from your insights, Nitish, and
Thank you. Thank you very much.
we are almost done with the
Yeah.
session. It's almost an hour now. And I'm very sure that the audience would have definitely got immensely benefited by your time and your insights.
Thank
Those who want to watch similar videos, they can definitely subscribe to the YouTube channel of LawSikho, and you can stay tuned to more such webinars in coming days or weeks. Thank you so much. You all have a great part of the remaining day, which is there. This is your
thank
host, Kumar Nikhil, with our guest, Advocate Nitish Banka.
thank
Thanks
you.
a lot.
Thank you. Thank you.
Thank you.
Thank you.